Just testing my mic.
I can hear you.
You can hear me. Okay, I was trying to test it out, but I have a separate microphone that I use and it's showing as red. So that's interesting. All right, good. I'm glad you can hear. Thank you.
You're welcome.
Good morning, everyone. Before we officially call our case, let me just check in with my court reporter.
I'm ready.
Great, thank you. All right, now calling proceeding number 24M-0274R. This is a proceeding that concerns the development of the template construction and maintenance agreements and preliminary engineering agreements for use in public crossing projects in Colorado, consistent with Rule 7212 of the Commission's rules regulating railroads, rail fixed guideways, transportation by rail, and rail crossings, which is found at 4 Code of Colorado Regulations 723-7. This pre-hearing conference was scheduled by decision number R24-0560-I this September 5th at approximately 9:30 a.m. My name is Melody Mirbaba, and I am the administrative law judge assigned to hear this case. We have a court reporter taking down everything that's being said. This hearing is being recorded, and it is also being webcast, both the audio and the video. I want to start by finding out who we have here today with us. And I'll just say, if I mispronounce your name or use an incorrect gender pronoun I'm referring to, please just correct me. I mean, no offense. It's a lot of people to keep track of, so I'm going to try to take really good notes so that I don't make any kind of errors like that moving forward. What I'm going to do, before I start calling on people using the screen name that's been identified for you, I want to see, because I've got like a list here of entities who have indicated that they're going to participate in this proceeding. But I understand, based on looking at many of the filings, that we have a number of entities may be represented by one attorney. And so before calling on everybody individually, I want to check in with that attorney and see if you could let us know who you're here representing, Mr. Dittman, Brandon Dittman, and then we can move on to everybody else.
Well, thank you, Judge Mirbaba. So I am representing the Colorado Communication Utility Alliance, which includes 64 municipal governments. In addition, I'm representing the city of Aurora, the city of Arvada, and the town of Hayden.
All right, thank you. Before I move on to call on anybody else individually, is there any other attorney who is in a similar position to Mr. Dittman, who is representing more than one participant in this case? Okay, I'm going to take that silence to mean no. So let me just kind of run through my list, and I will say it's possible that I've missed somebody. So once I've gone through this list, then I'll come back and see if I've missed anyone. Okay, I want to call on the person identified on the screen as Caitlin Werner.
Good morning, Your Honor. Caitlin Warner at Quinteros, Prieto, Wood and Boyer. I'm here representing BNSF Railway.
Thank you. All right, I want to call on the person identified on the screen as Lindsay. I'm sorry, I'm going to have to put better glasses on to be able to read today. Sorry, Lindsay Ahern, is that right?
That is right. Thank you, Your Honor. This is Lindsay Ahern on behalf of Union Pacific with the law firm of Greenberg Traurig.
All right, good morning. All right, now let's move on. I see we do have a couple of people who have indicated on the screen who they're here for. We've got two folks. In addition to counsel for Union Pacific, it looks like we've got a Nathan Anderson and a Josephine Jordan. And I am somewhat familiar with these names from the rulemaking hearing, so I'm not going to call on you since it's pretty clear who you're here for. Let's see about the person identified on the screen, our Zoom screen, as Williams SCN. And I will say, for those of you I haven't called on yet, if you could please, to the extent that you're able, change the name on your screen to be your name. That'll make it much easier moving forward.
Hi, good morning, Your Honor. My name is Chris Williams. I'm the CDOT Railroad Program Manager.
All right, good morning, Mr. Williams. Thank you for being here. And do you have counsel with you today? Because I think I see Greg Carson on our screen as well.
Yes, Greg is here.
Yes, Your Honor.
Good morning, Mr. Carson. All right, let's move on to the person identified as Paul Kenny.
Hello, Your Honor. Paul Kenny, Denver Transit Operators General Manager. Good morning.
Good morning, thank you. All right, let's check in with the person identified on my screen as Cheryl Townley.
Cheryl Townlin, I'm with BNSF Railway.
Okay. I want to call on the person identified as Heather Jarvis. I'll just note on the screen, Heather Jarvis has Fort Collins written next to her name. And so probably that's who she's here for, but if you could unmute yourself. All right, I'm going to come back to
In your honor, if I may, I can confirm that Heather Jarvis is with the city attorney's office in Fort Collins.
Okay, thank you. I appreciate that, Mr. Denman. All right, let's move to the person identified as Rebecca Greenberg.
Good morning, Rebecca Greenberg with the City Attorney's Office with Colorado Springs.
Colorado Springs, okay, good morning.
Your Honor, I could not unmute or start my video, but now I have been able to. And yes, thank you, Brandon, for confirming that I'm with the City of Fort Collins.
Great, thank you. Good morning.
Good morning.
I also just will note we've got another individual for BNSF, at least based on the screen name, Melissa Cannon. So I'm not going to call on you to introduce yourself. Let me call on the person identified as Tashina. I'm sorry, yeah, Tashina Beard or Bird.
Yes, it's Tashina Bird. I'm in-house counsel for BNSF.
Okay, thank you. Good morning.
Good morning.
Pretty name. All right, let me call on the person identified as Nick Limberpoulos.
Good morning, Your Honor. It's Nick Limberopoulos, Associate General Counsel on behalf of RTD.
Great, thank you, and I apologize for mispronouncing your name.
Oh, no worries.
I see we've got someone identified as David Oldham with the PUC. Let me just check in to make sure you're not here for a party.
Good morning, Your Honor. Correct. David Oldham with the PUC. Thank you.
Okay, great. And let's call on the person identified as Sean Lanka or Lanka.
Yeah, Sean Lake, Union Pacific Law Department. Ooh.
That tends to happen if you're connected through more than one device, and it looks like you are. Though it probably shouldn't have, because it looked like your other device was muted. So if you just stay muted unless we need to hear from you, then we should be able to avoid that background noise. All right, let's see. I want to call on the person identified as Thomas Snyder.
Good morning, Your Honor. Tom Snyder. I'm an attorney with Kutek Rock, and I'm here on behalf of the city of Greeley.
All right. Good morning. I want to call on the person identified as Jeff Seaman.
Good morning, Your Honor. Jeff Seaman on behalf of BNSF Railway.
Got a good showing from BNSF today.
Yes, thank you.
All right, and let's see, I want to call on the person identified as Matthew Conroy.
Good morning, Your Honor. Matthew Conroy with the Weld County Attorney's Office, appearing on behalf of Weld County.
Good morning. All right, let me call on the person identified as Lance's iPhone 2.
So this is Lance Kippen, representing Union Pacific.
Okay, good morning. And then I think this is the last, possibly the last person, Rafer Nichols.
Yeah, Rafer Nichols representing BNSF Railway.
All right. And I believe the only person I have not checked in with, the only, I guess, screen name I haven't really checked in with, I think is probably my poll reporter. Harriet, is that you as HSWDE?
Yeah, they kind of lost my, I think it's supposed to be my email, but they forgot the V, so that's me.
Okay, well, hopefully we can fix that moving forward. I think that my, our legal assistant might have something to share with me because I've got to raise a hand. So is it Casey or Stephanie today? I'm not sure.
It's Casey. I was just gonna let you know there's a second, if you click to the right, there's a second screen and it looks like there's 1 or 2 people that might have been missed at the bottom on that next screen.
Yes, thank you. I normally see that little arrow, but I just happened to miss it. I appreciate that. Yes, I think that there are 2 names here I haven't called on. They look somewhat familiar to me. So I see Richard Corner, that's Koerner, listed as for Union Pacific. And you can unmute yourself if I've got that wrong and let me know. Otherwise, we've got you in the record.
Good morning, Your Honor. That's correct.
Okay, great. And then Amber Stoffels.
Good morning, Amber Stoffels, Manager Public Projects with Union Pacific.
Okay, yeah, your name was familiar. I thought you might be with Union Pacific. All right, so did I miss anybody? And if I did, just unmute yourself, turn on your screen and tell us who you are. Okay, and I'm just going to run through. So I tried to make up a list of who I was sort of expecting might appear today. And I just want to run through that because I'm not sure I've heard from everybody or, do we have anybody for the town of Castle Rock here? Do we have anybody for the town of Tinmouth here? Or Tinmouth? Do we have anybody for Larimer County here? All right, well, that covers my list. And if anybody else joins us during the course of the hearing, I'll see if we can get them in the record. So this is not an adjudicatory proceeding. This is going to be a little bit more like a rulemaking, but frankly, it's been designated as an administrative proceeding. So strictly speaking, you know, entries of appearances, we don't have parties. We have participants in this case, but I just thought, at least as a starting point, it would be really helpful to have in the record, you know, who we have here with us today, as we figure out together how to move this forward. So, in the decision that I issued setting this hearing, I explained that the purpose of this hearing is to come up with a plan to move this case forward. I did outline my thoughts on what might be the most appropriate next steps, and that would be that I anticipate, and this is really, I think, what the commission was anticipating when it opened this proceeding, that participants, being those that would be using these agreements, would be the primary drivers for coming up with the agreements, the language that'll go in these templates, and that I, on behalf of the commission, can intercede and assist as necessary when we've maybe hit a loggerheads. And I think ultimately I will need to issue a decision out of this case, adopting the templates that will be used pursuant to Rule 72, I think it was 7214, which, will ultimately become a commission decision, if possibly in the future. So, I guess my first question is, whether everybody thinks there is a different approach that we ought to use as opposed to starting with having informal workshop discussions among all of you that I would not be a part of. And I'll say the reason why I thought that might be a good starting point is I really want you all to be able to talk with each other openly and frankly, and I worry that if we're doing that on the record and I'm involved, your conversations may not be as fruitful as they might otherwise be if you had the opportunity to talk to each other without me present. So I guess my first question is, what are your thoughts on the approach that I've outlined both here today and the decision that I issued? And that would be setting some deadlines for some informal workshops you would all do. And we would either have somebody agree to file a status report, let me know how that's going so I can determine whether we need to move it into a more formal setting. Or I could even just set a hearing, another hearing date where we could talk about where things are. Mr. Carson, you have raised a hand, so let's hear what you have to say.
Yes, Your Honor. That's Greg Carson. Previously, we have submitted our master agreements that we have with BNSF and Union Pacific Railroad, and we're hoping to be, originally we were approved to continue to use those because we spent several years working those out. So I don't know that there's a need for CDOT to participate if we're allowed to continue using those master agreements that we've already got in place.
Yes, CDOT was and is specifically exempted and for that exact reason. And if CDOT does not wish to participate, since you have now filed your templates, that was really one of the primary thing we were really hoping to get from CDOT. I think that would be fine, but I will say the experience that CDOT has had in negotiating those agreements and getting to those terms and all of the work that CDOT does throughout the state that involves these same issues could actually be very helpful. I am certainly not going to say you have to participate. I would certainly appreciate having some insight at some point from CDOT and some assistance if CDOT wishes to do so, but it is going to be up to CDOT to do that at this point.
Okay, thanks.
All right, thank you. Okay, so back to really the bottom line question was, I just want to hear people's thoughts on how we should proceed, whether you think what I've outlined is a good approach or if you have any other ideas.
Judge, this is Lindsay Ahern on behalf of Union Pacific. We were questioning whether it would be productive in advance of any workshops to have the submission of comments on the templates submitted thus far, which we think might make those workshops more productive, knowing in advance what some of the issues or sticking points might be.
Okay. We can certainly come up with a timeline that could allow for that. Ms. Werner, before I call on you, I want to call on Mr. Dittman because he had raised his hand for a little while here. Mr. Dittman?
Thank you, Your Honor. So I want to address a couple things concerning the process and some things I've seen already in this proceeding, which I think should be addressed or are worth noting. So first, as Your Honor kind of I think recognized in your decision, there's been a lot of issues in this proceeding with notice of service, which I've raised with commission staff. I think which is part of the reason why we're missing people today. And I try to get the word out, if you will, but what I've noticed is through the filings is that there's the PUC generated certificate of service has not listed all the parties that have said they're intended to participate. And so, for example, the notice for this pre-hearing conference, I only knew about because one of my clients scanned it in and sent it to me. And so I think I've already, talked to Allison Torvik at the commission about that, but I think it is worth noting as to why, there maybe not has been the level of participation that you expected in this proceeding. So I just wanted to kind of raise it as an initial kind of preliminary matter.
Okay, let me just speak to that first before you move on. So yeah, that is something that I did notice. And I think it was just human error. I'm not the one that I don't serve decisions. I tend to try to look at that, to make sure everybody is getting served. And I think it was realized well after the fact that many people who should have been served via e-filings were not. And so there's probably like 1, 2, and 3 supplemental certificate of services for this hearing. And part of my thinking about this case is not adjudicatory. We don't have parties, we have participants. And if anybody who hasn't been able to appear today, even if they had notice, they're still going to be permitted to participate in this proceeding. We're not going to block anybody out of it. And I am hoping moving forward, we're not going to have service issues. One of the things that I put in my decision was to sort of outline why we had some service issues initially, because we were trying to treat this case from an initial point of view, like a rulemaking, where we send all the information out to everybody who might possibly be interested. A lot of those people are not registered with e-filings. It's via US mail. It takes a lot longer for them to get the notice. And then we aren't necessarily hearing back that they want to participate. So what I wanted to get out of, to get us moving forward, is to get really clear. Anybody who is going to participate has to tell me they're going to participate by making a filing in the case. And they've got to include an email address, because I cannot do remote hearings without an email address for them. Otherwise, I have to do what we did today, and that's post it on our website, which can create some risks of Zoom bombing, and we'd like to avoid that. So what I'm hoping is that we have at this point received notice of everybody who's going to participate, and that should streamline future service of decisions. Secondarily, though, if you, Mr. Dittman, I know that you've done a lot of representation for the CCUA, so you're probably in contact with a lot of the local governments and jurisdictions who were mailed the decision in this case, who have not joined in. You are welcome to reach out. I encourage all of you to reach out to your counterparts, because this is once these templates are done, they're done. I mean, it's going to be, I don't know what process would have to go into place to make any changes in the future. So we really need to get as much participation as possible. After this hearing, when I issue a decision, I am not going to have that decision served on everybody under the sun. It's only going to go to those who have entered an appearance in this case. So with that, Mr. Dittman, you may continue.
Thank you. And I appreciate that, Your Honor. We've been trying to get outreach to people that may be interested. Some just don't have the capacity, of course, to do that. Some don't have railroad crossings. My concern was the parties who have indicated an intent to participate and are not here or have not done anything in this case because they just haven't been served. So that was, my primary reason for raising that as a preliminary matter. Regarding in terms of the process moving forward, I agree this should, I conceptualize as working like a rulemaking more than anything else. And I think, what makes the most sense in my mind is a work kind of forward from the CDOT forms, which is what we kind of originally envisioned, and going through those as potentially as the model for a template moving forward, considering those have been negotiated with BNSF, UP, and CDOT and are acceptable to those parties. I think another thing that was kind of, I've noticed in the interim decision was like, the intent that parties submit their templates. And my response to that is like, from the municipal perspective, we don't have templates because, we are forced more or less to use what the railroads say we have to use. And so that's why, for the most part, no templates were submitted. I know the city of Greeley submitted a template for the rather unique circumstance of a utility crossing, which has recently been problematic for the municipal jurisdictions. But that's just explained. That's one of the reasons why we didn't have any templates to submit, because we use the railroads. In terms of, again, the process moving forward, I think starting off with informal discussions, moving forward from the CDOT templates makes sense. I'm not sure how far those can possibly get, to be honest. And some of these issues that I'm anticipating, we'll have in those informal discussions have been at loggerheads for years. And so I'm not sure how much kind of forward progress we can make, but I'm at least willing to attempt to do that, considering some of the good work we did in the rulemaking proceeding coming to terms. And I think that there may only be one, kind of informal discussion on those templates, and we may need the assistance of the ALJ to help kind of move some of these issues forward.
Yeah, and I'm not underestimating the task that we have before us. Obviously, I was the judge in the rulemaking, so I know the history. I also remember how far you all came when you did come together and meet and have an opportunity. So I'm not going to underestimate your ability to reach some agreements. It is possible. But of course, the reason for the templates is simply because there have been loggerheads between railroads and the local governments that even on a single individual project can go on for 2 years just to get an agreement. And I don't anticipate our templates solving every issue that you all might come across when you're contracting. I anticipate trying to solve the issues that you should not be arguing about, the things that really should be no-brainers, like following Colorado law. So I'm hoping at least with that, we can get some progress, that we can move this forward. And I don't know, I know that the rule requires these agreements to, I think, be used starting in November. I'm not sure we're going to have it done by then. I can certainly talk to you all if you would like about thoughts on what can be done so that no one's going to be out of compliance. But I don't want to digress too much. I've got Ms. Werner waiting to chime in. If you could go ahead and chime in and let me know what you think about how we ought to move this forward.
Yes, thank you, Your Honor. I think I have a little bit of a different opinion and maybe more in line with Ms. Ahern. I think if generally the road authorities or other entities want to provide comments, then maybe it makes sense for BNSF and or UP to look at those and address those. I think we would actually get further in having fruitful discussions, or at least attempting to, rather than trying to drill it down for versus the. So I'm more of the opinion that we get comments, allow the railroads to consider those comments, address them, respond to them, rather than having to fight over specific wordage from the get-go.
Yeah. Can you all hear me for a second? I thought I might have accidentally muted myself. Okay. Yeah, and I mean, I'm not hearing any opposition to that as an approach. And I think that we can build in a timeline that would allow for BNSF, Union Pacific, or anybody else to submit comments on any of the templates that have been filed. I tend to agree with Mr. Dittman that the CDOT template agreements could be a really good starting point. So if we are going to get comments, I think it would be helpful to hear what folks think about those templates. And but I think also both Union Pacific and BNSF have also submitted a good number of exhibits, that maybe templates or samples that the local governments might also want to comment on. So I don't see any problem with that. I think it's just a matter of coming up with a timeline that will allow for that, and then we can build in informal workshop discussion among all of you. Ms. Werner, I didn't really hear from you on what you thought about having a comment, time to digest, and then an informal as opposed to more formal discussion with me involved.
And generally, I think see how it plays out, but I'm thinking, and so I was responding specifically to maybe having one informal and proceeding to rulemaking. I'm thinking more of a collaborative process with the parties with deadlines to exchange back and forth before we set that up, to see where it really is, if the parties may have concerns or disagree, and see what is negotiable and what isn't to each side.
So are you saying you think that after the comments, an informal discussion among the parties is a good approach?
Correct.
Okay. Whether we call it an informal discussion or an informal workshop, to me, it's the same thing. I think workshop is just the terminology that the commission tends to use for this sort of a thing. So there's no real substantive difference. All right. Does anybody else have any thoughts on how we ought to proceed? And if you do, you could just unmute yourself, turn your camera on, and tell me state your name, and then let us know your thoughts.
Hi, this is Heather Jarvis from Fort Collins, and in concept, I hear that we will comment on the different templates that have been submitted, but I'm a little uncertain how, if these are going to be these enormous track changes documents, or if we're going to submit them sort of in a brief form, or in a, like we would submit something to the PUC. How does anyone on this workshop envision the going through and submitting comments?
Obviously there are a lot of different documents that have been submitted. And so I would say, I know everybody has limited resources. I mean, we're not unlimited in the amount of time that can be dedicated to this. So what I would suggest is focusing on the ones that the template agreements that possibly have the most potential of getting us where we need to go. And focusing on those. And if, for example, there's a template that is there's so many things that a participant would disagree with it, it'd be too hard to comment on. It could be just stated very simply like that there are many issues with this. And rather than detailing every little problem, we want to focus on the ones that will get us further. In terms of format, that's really up to all of you, and what you all think is going to be most productive in moving to a resolution. I mean, if it might be most productive just to talk about the concept that might be represented in certain language, as opposed to the exact words that are in the agreement. But I can't really tell you what's going to be most helpful. It's really going to be up to all of you. Ms. Werner, do you have some thoughts?
Yeah, if I can clarify it, sorry if I didn't express it earlier. That's what I was saying, was more if we have high level comments as opposed to, that's why I said the versus the, rather than the red lines. I think if we have high level comments and then the railroads digest that and provide responses so that we're not getting caught into the nitty gritty and the parties can really identify what's truly important to them and address it at a high level rather than getting into the weeds initially, and through more formal rulemaking, as I think that is where we'll kind of stop before we start if we go to that approach.
Okay. Does anybody else want to chime in? Okay, and then one other thing before I start just figuring out timelines. Mr. Dittman, you can go ahead and unmute yourself.
Thank you. I was waiting to see if anybody else had any comments. So in response to Ms. Werner's comments, my only concern, I mean, I think conceptually we would be fine with that. I think, yeah, as your honor has laid out, I mean, I think we have high level concerns, which are known to the railroads, which come up in every one of these negotiations, which we can certainly repeat for the record. Here, my only concern is that this back and forth doesn't go on forever, and filing written comments, because I don't think it's going to get us anywhere. Quite frankly, I think it's good to identify what the issues are for the record. But I don't think that period should be indefinite. We should have maybe one submitting of comments and one reply potentially, and then go straight into trying to work through the issues. Because I think for us who have been involved in this for a long time, the same issues show up every time. So that's my only concern. Is I don't want to waste administrative resources through multiple successive rounds of commenting.
I'm not at this point willing to say I'm going to only allow one round, because I just don't know. I don't know what's going to be. I think I have to see how it all plays out from a starting point. So I don't want to limit people's ability right now to provide their input. But I understand. I mean, we do need to move this forward, and I don't want this to go on indefinitely. I don't think we're going to have it done by November, though. I think we just have to be realistic. And at the end of the day, these contracts, these are big, and this has been a big problem for everybody for a very long time. And so I don't know that we're going to necessarily be able to overcome things very quickly. I think we move it forward in a timely manner. We try not to drag it out, do our best. But I want to do our best to do it right from the get-go rather than rushed. But I do hear you, Mr. Dimon. I understand. I fully understand the background of how we've come to be here today. And I understand both sides. I understand that the railroads are, I know, very unhappy about this. This is not something the railroads would want. But you were here and I appreciate that you were here. I appreciate your input and your willingness to participate and let us hear your thoughts and your perspective. And I'm going to remain positive and hopeful that we'll be able to come to something everybody can live with. Okay, why don't I'm just going to pull up my calendar here because I want to just sort of look forward at a trajectory. Okay. So I am thinking September 19th, that's 2 weeks from today. We could be the deadline to file initial comments on any of the templates or sample agreements that have been suggested and filed. And then I do want to allow for responsive comments to those because that'll give us a better picture of the full perspective of the party or the participant. You know what, instead of September 19th, we'll make it September 23rd. That's a couple more days. And then October 21st for responsive comments. And again, this is not an adjudicatory proceeding. So if you choose not to file comments or responsive comments, that's not going to be held against you. It's not going to be perceived as waiving anything. It's just your opportunity to put something in the record. All right, and then from there, let's see. I would like to set a December 2nd deadline for the participants who are interested to come together informally for a discussion or a workshop, however you want to call it. That gives you plenty, it should be plenty of time to digest what's been filed and all those comments and identify a date that you can all get together. So I want that meeting to happen by December 2nd. And then I want to call on folks to see your thoughts on whether we should just hold a status conference right after that, or whether it, you know, somebody would be willing to file a status report to say, how did that go? And maybe if there is any consensus on what the next step should be. Does Union Pacific or BNSF have any thoughts on that? Whether we ought to proceed with the status report versus the status conference after that first meeting? Mr. Dittman, what about you and your clients?
Yeah, I think, you know, at least from my perspective, it may be more efficient just to have a status conference, just because there could be, you know, two opposing status conference reports. And, you know, it's another filing we have to draft and all review and agree upon. And so it may make sense just to, you know, maybe file a notice that we've had that meeting whenever it happens. And then have a status conference where we can each, you know, say what our perspectives are and how it went and what we think the way forward is. And hopefully there'll be a mutual, you know, joint kind of report given back. But
I'm fine with doing that way. I mean, it does make it easier. I would think it would make it easier on all of you. Ms. Warner?
I don't have any per se objection to that. I just note that I know, it's possible we may be getting separate comments from a dozen different road authorities. And so I'm optimistic, but I'm wondering if a little less than a month to address comments from various parties as opposed to two different templates, whether that's going to be enough time.
I don't know what deadline you're objecting to.
Oh, sorry. I was wondering if the October 21st is realistic in light of potentially receiving various comments from various different road authorities on our agreements, that we'd have to address each and every single one of them.
I mean, that's about a month between initial comments and responsive comments. You want more than a month?
Correct. Well, like I said, Your Honor, I'm optimistic. I don't know realistically. As Mr. Dittman said earlier, we don't really know who all will be participating. It's possible that we have to address, a dozen comments on various issues that may vary in large or slight degrees. So I just wanted to lay that on the record. I'm optimistic, but I'm wondering if that may present a problem.
Well, do you have a proposal then of what you think would be a better timeline?
In general, I'm just thinking November 11th, just because we are going to receive, and I remember with the Finding Authority, it was, various comments from various parties that did take a long time to review and address each one from each entity or in here each participant.
You know what I can do is I don't have a problem allowing for more time. We are setting deadlines and we're moving this forward, and I think 1 to 2 weeks isn't going to be, at the end of the day, a huge ask. I am thinking though, let's go with November 4th. So November 11th is Veterans Day in any event. So the best I would be able to do would, be the day before or the day after that. So let's just go with November 4th. That's almost the amount of time that you asked for, and it's over a month. Do you think that'll work?
I do, and I also welcome Ms. Ahern's thoughts. Thank you, Your Honor.
Sure. Anybody else that wants to chime in, I welcome your thoughts.
I don't have any oppositions to the plan thus far.
Okay. And Mr. Dittman?
Yeah, I don't have any oppositions either. I mean, I will say just, which I think everyone will understand, I believe that there's not going to be there's probably maybe 5 parties that will file comments, if I didn't anticipate, at least from our end. I think you're going to see a lot of the same issues in all of them, if I were to guess, but.
Yeah. I don't think we know. And I mean, and to be clear, these are not mandatory, these comments. This is permissive. This is anybody who is joined into this case gets to decide for their own how much they want to participate. All right, so we're looking at September 23rd. And the reason why I set that only within 2 weeks is that most of the stuff has been filed. It's not new as we sit here today, and that's a little over 2 weeks. And then that'll be for any initial comments on templates or proposed templates that have been filed thus far. And then November 4th for responsive comments. I will say if additional templates are filed after our hearing or after that, or getting up really close to that September 23rd deadline, I will not have a problem with anybody submitting anything in response to any new documents that ended up getting filed. I'm just hoping we can gather as much as we can by that November 4th deadline to have a clearer picture of everybody's thinking and positions before we have this anticipated your informal workshop. So I had originally set December 2nd as a deadline by which that informal discussion / workshop should be held. But with responsive comments now being on November 4th, I want to give you guys a little bit more time. So let me just look back at the calendar and see. Okay, so I'm gonna say by December 16th. Your informal discussion / workshop session should be held. The other good news is requiring everybody to file an entry in the case, including your email. You should all be able to contact each other pretty easily to coordinate this. And I am thinking just to make it a little bit less resource intensive for all of you, rather than having somebody file a status report. After that, we'll just do a status conference and I'll hear from all of you and we can figure out a plan from there. So I'm going to just look at some dates here, and I'm thinking about the week of December 16th. I know that we'll get at that point kind of close to where people might be traveling. So I guess I'll start by saying, are there any, I was looking at maybe the 17th of December, the 17th or the 19th. I'm hoping that's early enough that we won't have conflicts for a quick status conference, and it will be held the same way we're doing this. So if you can appear from anywhere you happen to be at the time. Does anybody have any problems with the 17th or the 19th, or any preferences between?
I just prefer not the 17th.
Okay, no.
Unless it's in the afternoon.
Okay. And Mr. Dittman?
Yeah, I was gonna say I prefer the 17th, but I could do 17th in the afternoon or on the 19th in the afternoon, just not in the morning.
Okay, I'll go with Brandon's then. I'm sorry, Your Honor. I just spoke out of turn. I wasn't called on.
No, you're fine. 17th afternoon for both of you.
Yeah, like maybe after 2:30 or something.
Okay. Ms. Ahern, you're unmuted, so I wasn't sure if you had something you wanted to chime in on there.
I don't. That works for me, for what it's worth.
Okay, great. So looking at December 17th, I'm going to just pause. If anybody has any conflicts with that, speak up now. Okay, and my entire afternoon is wide open that day. Why don't we go with 3 o'clock? That gives a little bit of buffer, and that hopefully should be plenty of time. And this round, I anticipate that the Zoom information will be emailed to people and will not be posted on our website. I mean, that might change if it's looking impossible to be able to do that. And again, any of you who know folks that would want to participate in this, please just tell them that make sure they've entered in the case and they provided an email. I really want everybody, if possible, to register for e-filings, but I can't force that. However, if those that are registered for e-filings, they get decisions very quickly outside of this one weird anomaly we had in this case, which I will make sure doesn't happen again. Okay, so just let me run through our dates that we've come together with. September 23rd will be the deadline to submit comments on any templates or proposed templates that have been filed. November 4th will be the deadline for responsive comments. The participants are directed to hold at least one informal workshop or discussion session by December 16th. And then on December 17th, we will have a status conference at 3 o'clock that will be held remotely via Zoom. I'm not going to require the parties or participants, to submit a filing providing notice that you've done the informal session. I think we can get that on the record during our status conference. However, if you are unable for some reason to not get together before that deadline, I will need to know about that, because I'm not going to, we might want to just push the status conference back, because if we just hold that to hear that you didn't have your meeting, it's going to be a waste of time. Is there anything else you all think we ought to try to address today? Yes, Mr. Dittman.
Thank you, Your Honor. So an issue that you already brought up kind of briefly is that there are, at least I'm aware of, several projects that are at the stage where they may need a C&M agreement pretty soon. And then, past November 1st, I believe it is, we're required to use the template. So we'll need some sort of interim guidance to what to do for whatever period between November and whenever this rulemaking concludes.
So, I mean, if we don't have templates, obviously nobody can comply with that rule. It's impossible. So this would be a very prime case situation to seek a, or for the commission to grant a waiver of that rule, at least temporarily. And there are a number of ways to go about that. It's commission can decide that take it up on its own, or somebody can file a petition. And Mr. Dittman, if you were to file a petition, I think that would move it forward, or Union Pacific or BNSF or anyone would file a petition seeking a waiver. Let me just grab, I want to point you to the rule. And the reason we have to do it this way is that's how waivers work. We have a rule about how we're going to waive a rule, and one that might apply more broadly like this. I think we do want to tee it up properly before the commission. I think it's rule. Hold on a second. Yeah, it's rule 1003. Again, though, the commission can take it up on its own motion. I don't really have any control over when the commission decides to do something like that. I would say if you want to just wait and see if the commission will decide to do that, hold off until mid-October to file a petition. Because maybe by that point, if they have decided, they will have noticed that, and that might save everybody some time and resources. Mr. Dittman?
Yeah, I just wanted to kind of respond briefly. I appreciate the ALJ's advice. I have one project which may be kind of in that range where it may need to get a waiver, but I think certainly my advice to my clients would be to wait until they need it and then file it. So I wouldn't anticipate that happening until sometime in October at the earliest, probably late October, more likely November, December. But there's at least a possibility. I'm thinking of one particular project which might run into that issue. So
Sure. I understand. And I think right now it would be very premature for the commission to take it up on their own motion, because this is our first real action and moving this forward. But I'm going to be issuing a decision. There's going to be a timeline laid out in the public. Commission, may become aware of, and it may become obvious at that point that this isn't about just one local government and one project, that this is really this is for everybody. So the commission may at that point, once we have something that's issued in this case, this decision I'm going to write, may decide to take it up on its own, and that might save everybody time and effort. But again, I don't have any control over whether the commission decides to do that. Okay, any other issues that we should try to address before we adjourn our hearing? All right, I'm going to take everybody's silence to mean that we've covered everything that we needed to cover today. I am going to issue a written decision that will outline everything that has happened, and including this timeline that we put together. And from there, I will see you all on December 17th at 3 o'clock. I want to again express my appreciation for your willingness to work together and to participate in this. I know this isn't necessarily going to be the easiest thing for all the people who enter into these contracts. This is a very different approach than what has been going on for years and years and years. But it is my genuine hope that all of these efforts will result in something that will be useful for everybody involved. Okay, so with that, we'll go ahead and adjourn our hearing. Thank you all.
Thank you, Your Honor.
Your Honor.
Thank you, Your Honor.
Your Honor.